because I had clerked for a criminal trial judge when I first got out of law school. So that was kind of what I knew the best at that point. But I tried a case. I had a client who was a co-defendant in a case charged with breaking and entering, or attempted breaking and entering. And a police officer from the municipality, actually a lieutenant from the municipality, claimed to have witnessed my client and the other co-defendant with this attempted break-in. And my client got away, but he found my client back at the house because he knew the family. And the family had 7 sons. And he picked my guy out and said he labeled him, identified him in his police report. Well, and this wasn't really his name, but my client's name was Sam, which started with an S. And he had 6 brothers, and they all had different initials to begin their names. And he had a brother, Larry. And in the and the cop testified he knew the whole family, and he knew all of the kids very well, and he knew them all by name and could identify them. And in his police report, he wrote L. Smith as to identify my client, whose name was Sam, that started with an S. So we go through the whole trial, and the prosecutor did not call the co-defendant. He just called the police officer. And I went to the police officer, went through a whole 30, 45-minute cross-examination, and then said, you have been a cop for a long time, and you know how to do reports, and you've been writing them your whole life, and you're very good at it, and you wouldn't put anything in the report that wasn't correct, and you double-check everything and make sure you got it right. And he's yes. And I said, and what is my client's name? He said, Sam Smith. I said, what does Sam Smith's first name start with? He said, S. I said, let me show you your police report. What initial did you put in for the co-defendant who you say is my client? He said, L. I said, L is not S, is it? He said, no. And I sat down. And in my closing argument, I said, the cop who knows everybody very well put the wrong initial in because it wasn't my kid he saw. Well, the jury, some members of the jury bought that, some didn't, so the jury hung. We had to try the case a second time. This time, and I can't surprise the officer on cross-examination again because I already played that card. But I could still make the point in cross-examination, and he knew it was coming, and he conceded. He screwed up. But the prosecutor brought in the co-defendant. Now, in the courtroom, there are 14 white jurors sitting in the jury box. There's a white prosecutor. There's me, the white criminal defense attorney. There's a white judge, there's a white court clerk, and there's 2 white sheriff's officers who are maintaining security. And there are 2 black men in the courtroom, my client and the co-defendant. The prosecutor puts the co-defendant on. He had worked out a plea bargain and had agreed to testify. And he asks the co-defendant the $64,000 question, do you see the co-defendant with you? Or who was with you here in the courtroom? This kid looked at everybody in the courtroom except my client. He even looked at the judge, and he looked at each one of the jurors. I mean, he went along and never looked at my kid and said, no, I don't see him. Jury was out for half an hour, came back not guilty on all charges. So, brilliant cross-examination gets me a hung jury. And a co-defendant who's looking to protect my kid gets him not guilty. It was, and the prosecutor I tried the case against is a friend of mine, and we tried this case 30 years ago. We still laugh about it because you can't make it up. So I tried another criminal case years ago with a father and son who were the co-defendants on a drug possession charge out of Marlborough State Psychiatric Hospital, which no longer exists. They closed it 20 years ago. But my client was the father and the co-defendant was the son. The son had an apartment on the grounds and had given keys to all of his friends who worked there so anybody could stay there. And Marlborough had its own police department who all went through the police academy were all qualified as law enforcement officers and so forth, and they all carried sidearms and the whole thing. And it was about a 2 or 3 week trial, and we tried the case. And I decided that there were 5 or 6 cops who were going to testify, and none of them had done any kind of diagrams or anything about the layout of the scene. And every time when they filed something against my guy, at my advice, my guy went and filed something against the cops. And every time my guy did something, the cops filed an amended police report. So we had like 5 police reports from each of the cops, and each police report was different. And so the cross-examination just took them through, well, you wrote the first police report this way, and your training says you put everything important into the police report, right? Yes. And so in this police report, you put in A, B, C. You didn't put anything else in, did you? No. And that was because it wasn't important, right? Yes. And then 2 days later, my client filed something, and you filed an amended police report, and you added these facts, didn't you? Yes. How come they weren't in the original report? I can't explain that. I don't know why. But when you did the second report, you certainly didn't omit anything, did you? No, I didn't. And then 3 days later, my client filed something else, and you filed the third amended report, didn't you? Yes, I did. And you put in these facts that weren't in either of the first 2 reports. What changed? And so you just keep building that. And then I got each cop to draw a diagram of the scene at 2 different points in the proceedings. And after I did the first cop, the prosecutor tried to use the diagrams as to lead the cops through testimony, and I objected because we had what's called a sequestration order, which means that the witnesses have to be out of the courtroom during testimony, and they can't talk to each other about what the testimony was. So, and the diagram was cross-examination, and so that was a violation of the sequestration order to use it in the direct examination of the next cop. And the prosecutor didn't think to have his own cops draw diagrams. Because in the heat of battle, you commit, you have a plan, and you come in, and in the heat of battle, it's hard to change plans. And when you haven't thought it through, if you change it and you screw it up, it's even worse. So you stick with your plan, and he stuck with his plan. And the second cop, I had to do the same 2 diagrams that looked nothing like the first cop's. And then the third cop did 2 diagrams that looked nothing like the first 2 cops. And then the fourth, and then the fifth. And then the police chief testified, and he drew a diagram that was completely different from the other 5. So I got 6 cops testifying about 6 different sets of diagrams, and each of them has written 3, 4, 5 different reports after various stages. It was hysterical. Jury was out for about, I think it was like a 6 or 7 count indictment. The jury was out for about 2 hours on my client, and they were out overnight on my client's son, but not guilty on everything. It was great. It was wonderful.
Mighty Merp is a production of the Law Office of Melissa Rosenblum.